Hi guys, I'm going to do a YouTube video for Chapter 4 in criminal law. I'll bring the camera up closer so you can see the board. I feel like I could use a studio assistant, but I'll run this down for you, so you're probably going to be looking at the board more than you're looking at me, but the important information's up here, okay? I am shooting outside today, so if you hear birds chirping or something, or maybe a car going past, I apologize. I'll pause a minute. Chapter 4 in your text is looking at evidentiary issues that are specific to criminal cases. I want you to take a look at the Klein case. It's in the appendix of your textbook. There are actually 4 cases in the appendix, and we will be going through all of them, so not a bad idea to go ahead and read through them. They're not long, and they'll give you a pretty good sense of the types of issues and evidence that can come up in criminal cases. Some of this will sound familiar to you because we've talked about evidence and admissibility issues previously, but we're going to be approaching it from specifically a criminal perspective. You know that in order for evidence to be admissible, there are some questions that we need to assess. Most importantly, we need to determine if it's relevant. Evidence that is not relevant is not admissible, okay, because it doesn't help to establish whether something did or did not happen. Secondly, we need to ask if that evidence is reliable. That is, can we authenticate it? Do we feel confident in the results that it's given us? And thirdly, we need to assess how prejudicial the evidence is. Remember that sometimes evidence that is both relevant and reliable might be excluded because it is considered too prejudicial. Okay. Direct versus circumstantial evidence. There are some examples in your textbook on page 94 that are specific to the Klein case in the appendix and the other cases in the appendix. So do take a look at that. It's just helpful to put in concrete terms. We're going to look at types of evidence. Again, these are going to seem familiar to you from previous class, but I put a little star here beside foundation, which we'll get to, but I just wanted to point out here that all types of evidence need some foundation laid. Okay, so put a note by it. We'll come back to it. Your textbook here calls physical evidence what we previously referred to as real evidence. Both terms are correct. You can use either one, but physical or real evidence are concrete, tangible things that you can touch. Okay, a bloody knife, a ripped shirt, something of that nature. Documentary evidence are paper, essentially paper. They can be electronic as well, but some type of document. Okay. Your textbook makes a good point here, and that is when working with documentary evidence in the office, do not mark the originals. Okay. It could make them inadmissible at trial. Make copies. Make sure you label the copy as a copy, just so that you don't get mixed up and accidentally mark the original copy. When I say mark, I mean make notes on, highlight, anything like that. Okay. Definitely you want to make notes about documentary evidence, but make sure you've done it on your copy, not the original. Third type of evidence, testimonial evidence. That involves witnesses giving their statements about what they have firsthand knowledge of. Okay. Remember that hearsay is excluded. There are some exceptions to the hearsay rule, but our general rule is that testimonial evidence needs to be based on first-hand knowledge. Okay. Lastly, demonstrative evidence. Those are things that tend to demonstrate or show what may have happened. So this can include recreations, it can include diagrams, things of that nature. I gave you guys an example of one I had seen in a trial that I was on the jury for, where it was a sexual assault case where they marked out with tape and some other demo items the size of a bathroom stall. Okay. Next, I want to talk about identification evidence. That is evidence that a particular suspect or person committed the crime they're accused of. Identification can be obtained in a couple of different ways. Most commonly, people usually think of a lineup, a police lineup, okay, where you put generally 5 or 6 people in a line, and you ask the victim or the witness to choose which person they saw. Okay. There are some issues with lineups that you need to be aware of. One, eyewitness testimony is not super reliable. Okay. It can be very good evidence, and it's evidence that juries usually give a lot of weight to. However, sometimes entirely unintentional on the part of the witness, they just make a mistake. Okay? When a person is a victim of a crime or witnesses a crime, it's a very traumatic experience for most people. Their memory can be clouded. It can be really hard. Try to think of what exactly your instructor, how about me? Try to think of what I was wearing last time you saw me in class, way back before spring break. Okay? Probably can't do it. I can't remember myself what I wore to our last class. Okay? So the farther away in time an identification is made, the harder it is to be sure that that identification is reliable. Okay? However, that being said, identification evidence from a lineup usually is admissible so long as constitutional restrictions are met. Okay? Number one, counsel has to be available. Okay? Secondly, you need to give some consideration to the makeup of the lineup. That is, who's participating. It is important that you not give away in any sense or indicate to the witness which suspect you think is the right one. That means that the suspects need to be similar in appearance and dress. You shouldn't place the suspect you think is the right one in the first place position and then nod towards them. So essentially you can't give any hints or clues to which one you think is the correct suspect. Okay. Going on, single suspect lineup. This is constitutionally impermissible. This involves the police putting basically one person in a lineup and then saying to a witness, is that the person? Okay. You haven't really given them any other options. Also, it makes it very difficult for a witness to say, no, I don't think so. Okay. Especially if they're unsure. They may just assume that you have the right person. Single suspect lineup is differentiated in your textbook from a one-person show-up, which is not necessarily constitutionally impermissible, but it's got a lot of hurdles to get over. Okay, it's not a good idea. Sometimes it is done out of necessity. Most commonly, you would see this kind of immediately during or after some kind of offense. That is, let's say a person is assaulted. A suspect is pulled out of the crowd or the house immediately afterward. Victim will sometimes still be sitting inside of a police car giving a statement. They may walk the suspect by to ask simply, is this the man you saw, or is this the woman you saw? Okay, is this the man or woman who assaulted you? So again, a one-person show-up is not necessarily inadmissible, but it has some hurdles to get over. Okay. Next thing to ask yourself, what happens if the ID is not good? That is, if it doesn't meet constitutional limitations. The sanction for an improper ID is that it may not be admissible in court. Okay. It's a pretty big sanction. One other thing to note here, though, is that the Fifth Amendment, which gives your protection against self-incrimination, does not protect against identifying marks like scars or tattoos. Okay? You don't have a constitutional protection not to have to show those things. So if a suspect is asked to display tattoo or a scar that a witness described, they must display that. Okay. Common types of evidence. Moving on, in criminal cases, most of these will be familiar to you. First off, DNA evidence. Okay, your textbook looks some at the development of DNA testing, the increase in both capacity, and efficiency over the years, the creation of DNA databases to help track criminals. Okay. DNA shows the presence of a defendant in a particular place. Okay. DNA cannot show motive or intent. Okay, so it can tell you that someone was there, but it can't tell you what their intent was. Okay, that you have to build through circumstantial evidence. That being said, DNA evidence is usually very persuasive to a jury. Okay. Fingerprints, another very common type of evidence in criminal cases. Computers have made fingerprinting and fingerprint matching much faster and more reliable. Okay. She used to be done by a hand system where they tried to find a certain number of matches between a suspect's prints and the prints on file. It's very time consuming, and it was a little bit subjective depending on who was doing the matching. Okay. Computers have improved this process substantially. Okay. Next, blood tests. Okay. Blood testing is different from DNA testing. Okay. Blood testing is sometimes called blood typing. And generally it's used to eliminate individuals. That is, that they can establish that it's not the correct blood type that they're looking for, so DNA testing is not needed. Okay? If you're looking for a suspect that has A positive blood, a blood type of O negative tells you that you don't need to test any further. Okay? It's not the right person. So it's used for elimination. Next type of evidence that you sometimes have in criminal cases, polygraph tests. We've talked about these previously, and that they have acknowledged reliability problems. Okay, that is, some people run very high-strung and nervous, and they may fail a polygraph test, or the results may indicate that they're not being truthful when they are. Alternatively, it is not uncommon for people, especially people with, psychopathic or sociopathic tendencies, who tend to lack empathy and lack a range of emotions and feelings, to be able to pass a polygraph test when they are lying. Okay, so they don't have the same kind of stress response that most of us do, and so it may indicate that they're being truthful when in fact they are not. Other people can just basically beat them through practice. Okay? People who are very good at meditating or controlling their autonomic stress response can also beat a polygraph test. So it doesn't mean that the police cannot use this in the process of gathering evidence. It just means that because of reliability problems, it will not be admitted at trial. Lastly, voice testing, also sometimes called voice stress testing. Just like the polygraph test, it's trying to pick up differences in stress level of the person being tested. Okay, can be done as a way to gather information, but cannot be used at trial because of reliability issues. Okay, now back to what we were talking about before, and that is a foundation. Okay, to admit evidence, the attorney has to lay a foundation for it. Is usually how we describe that. This is achieved by questioning a witness or witnesses with knowledge about how that evidence was obtained or how it was processed. What kind of testing procedures did they use? How was it handled in the lab or between the labs? Where was it collected? Who collected it? Okay, that kind of information is how you lay a foundation. The attorney cannot just testify to that himself. He must ask witnesses who have firsthand knowledge. Okay. Again, another topic that we've seen before is chain of custody. It's important in order to establish the authenticity of the evidence that you're presenting. Okay. Chain of custody is going to start when the evidence is collected, and it's going to run through basically trial. How was the evidence gathered in the first place? How was it handled? Where has it been stored? Was it labeled properly? Okay. Exclusionary evidence rule. Okay. Now we're looking at basically a sanction for when some evidence has been gathered in violation of a defendant's constitutional rights. Okay. Excuse me. Generally, evidence that is obtained in a violation of constitutional rights is not going to be admissible at trial. There are a few exceptions. We'll talk about those. But generally, bad evidence or evidence that's gathered impermissibly cannot be used. Okay. This also extends under what we call the fruit of the poisonous tree doctrine. Okay. That means that if you start out by gathering evidence in a constitutionally impermissible way, okay, any additional evidence that you gather after that, based on the first bad evidence that you got, can also not be admitted. Okay, this might work. Let's say a suspect's car or vehicle was searched without a warrant and without any exceptions to the warrant rule, and the police officers find a diary in the vehicle that basically lays out all the other people who were involved in the criminal act and what their part in it was. Okay, so under exclusionary evidence rule, since there wasn't a warrant and no exception, the diary could not be admitted. Fruit of the poisonous tree doctrine means any evidence that they found inside the diary, they could not follow up, basically, and use the names or other people in there to go track down other evidence. Okay, so it is a very harsh rule, exclusionary evidence, but our Supreme Court believes that it's necessary in order to basically, I hate to say it, but keep the police honest. That is, if we didn't have a harsh rule, then there would be no incentive for law enforcement to respect your constitutional rights. Okay. Exceptions. Well, again, I mentioned there are some exceptions to exclusionary evidence rule because it is such a harsh sanction. There are some ways around it when the circumstances call for it. First exception would be the inevitable discovery rule, okay, which basically means that the evidence would have been discovered anyway, even without the constitutional violation. It's inevitable that it would have been discovered, okay. Might take something like this. Let's say the defendant's vehicle was searched impermissibly in violation without a warrant or an exception. They found that the owner of the vehicle was listed on the registration in the glove box. Okay. The search is bad, that information would be bad. However, inevitably, the police would have discovered the owner of the vehicle. When it was impounded, when it was, the plates were run, inevitably they could have discovered who owned the vehicle. Okay, so that would probably be admissible. Second exception to the exclusionary evidence rule, good faith. That applies when the law enforcement officer believed that the warrant was good, but for some reason that they were not aware of, it turned out the warrant was no good. Okay, maybe there was a mistake on the warrant. Maybe there was a typo. Maybe there was some other minor issue. Okay, but the law enforcement officer had to believe in good faith that they were acting under a good warrant, a valid warrant. Finally, another exception that your textbook covers is the independent source rule. That is, the evidence is verified by an independent source that has no constitutional taint. When I say no constitutional taint, I mean would not fall under fruit of the poisonous tree doctrine. Okay. I'm sure you guys have covered this probably more extensively and in depth in some of your other criminal classes. However, like I said, your textbook deals with these sort of specifically as it relates to paralegals. One other thing I want to point out from this chapter is it does end discussing attorney-client privilege. Just as a reminder, attorney-client privilege only applies between an attorney and a client. Okay? You cannot have third parties present and still claim attorney-client privilege. Attorney-client privilege does not exist between client and paralegal. Okay? But when you have a valid attorney-client privilege, the attorney may refuse to testify about information that his client told him or her. Finally, take a look at People versus Muhammad. It's a California case from 2011, and it closes out the chapter in the textbook. Sorry. I think that's going to be it for this chapter. This is a little longer video than usual. Don't forget to take a look at that Klein case. Also read People versus Muhammad. I'll put you an assignment up probably later today that will likely have you brief this Muhammad case. It won't be due right away. I don't think you guys have even got to chapter 4 probably yet in your reading. But again, I'm trying to work a little ahead so that you can go at your own pace. That's it. I will see you guys soon.